Let me bring my guests into the conversation. Dr. Buzz still here with me in New York, and Don Schweitzer, criminal defense attorney out in Los Angeles. I'm going to ask you both the same question from your different vantage points, and that is this. It's about the reliability of ear witnesses. I talk a lot on this program about the unreliability of eyewitnesses. I think ear witnesses are equally problematic. And Donald, I'll start with you. First of all, our ears are not as reliable as juries may think, and our memories of what we think we heard can be influenced over time.
I agree with you. Anybody who's handled a multitude of cases as a lawyer or even as a police officer will tell you that people get it wrong quite frequently. But you know what? The defense has to show the jury that this guy could get it wrong, because if he goes unchecked, they have nothing else but to believe him, and that could be.
Well, but Donald, you know, it's hard enough to have an eyewitness expert come in and talk, you know, a Loftus type, talk about how bad eyewitness identification is as evidence. I don't think Fiddler's going to be letting in ear witness experts to talk about the fallibility of that.
I don't think that there's going to be an expert, but I think that through a real rigorous cross-examination, you could cause some doubt as to whether or not he heard what he says he heard. It could be done.
Yeah. Let's jump out to our friend and colleague, Beth, Don Schweitzer, who's there with you in Los Angeles, criminal defense attorney as well as former prosecutor. And Donald, this notion of accidental suicide, at least as a matter of law, is an oxymoron, right? You can't have an accidental suicide. Suicide requires something deliberate on the part of the actor. That's why attempted suicide is a crime in some jurisdictions. It requires a certain mens rea. So I think they were stuck, as we so often are, with the bad statements of their client. And they're trying to work with that.
Well, you know, it may be a suicide if somebody puts themselves in a high-risk situation. You know, they engage in such behavior that, you know, the result is going to be inevitable. And maybe they could get away with saying something like that. But I'm wondering if they're trying to set up something for a possible appeal later on. This 1101B evidence came in to rebut the possibility of mistake or accident.
Yes.
If they could say to the Court of Appeal it was a suicide, you know, maybe they're trying to do something with that.
Yeah, and you know, one of our guests did come on, a prosecutor, in fact. I call him a rabid prosecutor, Ernie Marrero, and he actually thinks the 1101B admission was an error by Judge Fiddler for precisely that reason. He doesn't think the defense will be there, the defense that the judge is anticipating in letting it in. I don't know that he's right, but it certainly remains to be seen, and I think you're right, Donald, that it could be an excellent issue on appeal if the defense is not accident.